We are now back to number 4, People versus Chizor. Mr. Varghese.
Thank you. Good morning, Justices of the Appellate Division. My name is Vinoo Varghese, and I represent the appellant, Mr. Chizor, here. I'm going to begin my argument by informing the Justices of the argument we didn't raise on appeal. We didn't raise a legal sufficiency argument. We didn't raise a verdict against the weight of the evidence argument, because with the evidence that was presented at trial and the evidence that was excluded at trial, the people certainly proved the case beyond a reasonable doubt. But that's why we're here. The lower court's ruling to not allow a short adjournment for a defense expert changed this case from a case with plenty of reasonable doubt to one without. No, of course not. But what she said was, if you look at her testimony on page 439, whether a child was being physically abused by their parent would be likely to disclose sexual abuse to that same parent. That objection was made overruled. She said that would increase the likelihood they wouldn't come forward because of fear a child would have. What is the likelihood that a child, page 440, what is the likelihood that a child would disclose sexual abuse when being evaluated by a psychiatric doctor? She responds, while it is possible some children might disclose, it is a lot easier to say no, nothing happened, than to have to, open up this whole can of worms. Everything she testified about matched the facts in this case, Your Honor. So therefore, when the defense was not allowed to call a witness, they were at extreme disadvantage. And then when you take into consideration the behavior of the ADA below, who can be likened to the Terminator because he just wouldn't stop. The judge repeatedly was arguing with this prosecutor, this ADA below, objecting in front of the jury, having an intense colloquy, arguing with him in front of the jury. And at a certain point, I almost, felt the exasperation of the lower court judge, because probably why he didn't want to grant the 2-day adjournment, because he didn't want to deal with ADA Schwarzenegger anymore. I mean, this is what happened below. Mr. Chizor did not stand a chance. And then when you take into account the cross-examination of him that went on.
I understand, but didn't the jury charge resolve any issues?
No, because Your Honor, it's a general admonition that arguments of counsel are not evidence, said once in preliminary instructions and once in closings, is not sufficient when you have a prosecutor, particularly in a sex crimes case. We all know, we've seen Law and Order Special Victims Unit, the most heinous crimes are dealt with by the Special Victims Unit.
Counselor, please, let's stick with this case. Counselor, please.
Yeah, but this is what—
We're not enamored by television. We're hearing this case.
Well, that's why we're here, Your Honor. I appreciate that. What I'm saying is that in a sex crimes case, which obviously the charges here are heinous, by definition, the charges alone, you have a 50-year-old pastor with 2 young girls, 9 and 12 at the time of the alleged incident.
And they subsequently found him in bed or admitted that they had been together when she was 18. Am I correct?
One person, one of the complainants said that is what happened, but that was one of the other things the prosecutor tried to go into. That was prohibited testimony, and yet he flouted all the lower court rules. And particularly when you look at the cross-examination, asked him, one of the girls testified that the man was not circumcised. He said he was circumcised at birth, and then he challenged him, where are your records? And the guy said to me, what man has a records from 50 years ago? Anybody has medical records of a procedure. And then he challenged him because where did this extend? Oh, you don't have records, therefore you must be lying. The man came from Africa in a village. I mean, even if he was here in America, he wouldn't have records. And then he said, you didn't get circumcised in a hospital? I mean, the sense of the cultural insensitivity of that argument, then going on asking him questions for which he didn't receive a pretrial Molyneux ruling about whether there was some sort of tax fraud going on. You keep records in your church, you pay your taxes, where are your financial documents? When you combine all of this, when you have all you have was Mr. Chizor on one side, you have the people and you have their expert, the eminently qualified Dr. Meltzer. No expert on the side of the defense. The jury had no choice but to convict.
Was victim 2 cross-examined on that, on her psychiatric treatment?
There were some questions asked, Your Honor, and Dr. Meltzer gave at best some.
No, not Dr. Meltzer. The second victim. Was she cross-examined on her psychiatric and mental health issues?
The second accuser, yes, Judge, the second accuser was, but as the Court of Appeals has held, that's not sufficient. Cross-examination is not sufficient for an area where, and see, we've cited this case in our brief, People v. Ryback, where an expert has given, when you have one side giving an expert and you don't have another side being able to counter that expert. You know, the people on their brief on page 18 listed a bunch of cases that deal with the discretion that a lower court judge has as to whether to grant an adjournment for a missing witness. None of these cases deal with experts. None of these cases are sex crimes cases. Excuse me, one case does, and that was a murder case. And that had nothing to do, and that was about polygraphs. Judge Spears, murder case, dealing with polygraphs. Polygraphs is, this was not a sexual assault case where you have two young victims, or complainants, accusers, accusing a 50-year-old man, and all they have is their testimony versus his testimony. Now, when you combine that with the people's experts and no testimony, no defense expert, and then combine that with the behavior.
I'm going to ask again, was not speculative?
Not at all. How can it be speculative? Because
I'm asking you that.
I'm sorry. Thank you. My apologies. It couldn't have been speculative because all we're dealing with was you have one expert, and the expert proffered was Dr. Burrell, somebody well known to the district attorney's offices, and somebody who would have been available with that same week. Judge, not next week, not over a weekend. That same week, that expert was available. And you're talking in none of the cases that people have put forth, none of them are sex crimes cases, and that deal with this specific issue.
But counsel, you know how hard it is to keep a jury at times. So why couldn't you get another expert? Was there a problem with that?
Judge, the medical records of the complainant were dropped on defense counsel at the beginning of voir dire. I credit counsel for his efforts in even being able to secure an expert. To get an expert on that drop of the dime is not easy. I've done it, right? You have to have somebody who's reviewing records. So he had sent the records out. He'd gotten confirmation from Dr. Burrell that he was going to be able to testify, just not immediately the next day. So, I mean, this is the people have made arguments, and in the end, they're saying, okay, you know what? It's okay for us to call an expert on these issues that are beyond the scope of the jurors, but the defense can't call an expert.
Counsel, I understand you wanting to call an expert to counter the people's expert, but would it be appropriate, in light of the nature of the case, for you to call an expert to talk about the witnesses' mental health issues? I mean, isn't that collateral? Doesn't that go beyond what's appropriate in a case like this, when you have a young victim who, the issue is really the guilt of the defendant, and you're calling an expert to talk about a victim's mental health issues?
Your Honor, first I take issue with the word victim. I mean, these are accusers, right? There was a jury verdict, so that's why we're here. These are complainants. And it is not outside.
No?
They're complainants.
They were just convicted. So.
Victims, I am a defense attorney. These are alleged victims, and no, it's not outside the spec, because what Dr. Burrell was going to testify about was the effect of this complainant's psychiatric history and on her ability to perceive, recall correctly. That's well within the testimony of an expert. There were some questions posed to the people's expert, and then in their brief, the people criticized counsel below for not asking other questions. But how can he do that? He doesn't know what this expert is going to say. He only knows what his expert is going to say, and he would have been committing malpractice if he went down a road that had led to some crazy conclusion that he couldn't have foreseen. So no, it is within the absolute ability of an expert to come in and speak about the complainant's ability to recall. And then when the people's expert put forth the theory that delayed reporting is normal in these kind of cases, well, then he had his full right, in which he proffered to the trial court, put his full right to bring in an expert to counter that expert.
All
Was
right.
there any indication in the psychiatric records that she was delusional, hallucinating, auditory hallucinations of any kind, that something that would impact on her ability to recall or to relay things in a realistic way? Is there anything that suggested that kind of a psychiatric problem?
Well, when you have, yes. So when there are, she said that she had been hallucinatory. And that is obviously something that needed to be explored. And so asking the other expert general questions or being able to cross-examine the alleged victim about this is not sufficient. The Court of Appeals has held that when there's a specific technical thing, that's what the expert is there for, to assist the jury in coming to determination. And Mr. Cheeser had his legs cut out from under him because he wasn't allowed a short adjournment. Judge,
Right.
this was something next week.
I think we've gone around on this enough times. You got your 15 minutes and then some, Mr. Varghese. We'll hear from the people. Thank you.